So this is what happens when you make the mistake of playing in your 9-year-old's parents' kids' soccer scrimmage. Turns out when my wife said, "You're old," she was right.
Did you win?
Who the hell knows? I got carted off the field.
Definitely did not win.
Okay, so I think there's a little bit of a debate about history that's actually relevant here, and I think I can't remember the aphorism now, but there is something about staking the high ground on events that have come before us. First of all, as Marvin pointed out, it is true. When you had dial-up ISPs, AT&T, Verizon, SBC, whatever the bells were called in those days, could not block your ability to access multiple dial-up ISPs. What he forgot to say was those ISPs themselves were unregulated. Okay. Second, and there's a theme, there's a real, I think, desire to paint this story as something happened in 2005. The world changed. Usually, the world changed is defined as we had the Brand X decision. Let me just tell you, I'm not the telecommunications expert that others are on this, but cable modem service has never been regulated. Brand X affirmed an explicit FCC finding that it was an information and unregulated. And before that, I suppose it was just murky. But I can tell you, our guys who were rolling out cable modem service were not complying with any economic regulation at the time and were free to roll it out in a manner that they thought made sense to serve their customers. Third point, and I'll try to, I know I don't want to steal everybody's time here. Third point on Comcast, and we probably need to have a longer conversation about Comcast. As Marvin said, Madison River, small rural telco, clearly blocked Vonage. I don't think there's a person on the planet that disagrees that that was a clear example of anti-competitive conduct. The FCC acted in a nanosecond to tell them to knock it off. Comcast was a different case, and it's actually relevant to my point, I think, which is as we went through first Chairman Kennard's vigilant restraint policy, which our industry supported, then Chairman Powell's 4 freedoms, which was sort of the predicate for the internet policy statement under then Chairman Kevin Martin. Our industry supported vigilant restraint, the 4 freedoms statement, and the internet policy statement. Why? Because they weren't regulation. They were principles. They were principles we abided by as a matter of business practice, so there was no harm in doing that. And at the time we were having a net neutrality debate, I would go up dutifully to Congress every 2 months to talk about net neutrality, and I would read from a statement somewhat like you would do if you were like sitting in a chair with your kidnapper right behind you, where I would forswear any desire lurking in my heart to block or to do all these nefarious things because they weren't happening and it wasn't part of our business model. And we know that if we are screwing around with our customers over here, Verizon or AT&T or RCN or somebody else or wireless now, it's going to take them away from us. So after 2005, from our vantage point, nothing else happened other than we had a little more clarity that the FCC's information services ruling, at least as it applied to us, had been affirmed. Again, nothing has actually changed. We're still talking about future speculative harms.
Thank you. I think you can sit right there.
Oh.
Okay. Commissioner McDowell started with what he thought was the first question, and I feel really good about this because this was my first question, and it has to do with the statutory authority to regulate in this area. Some have maintained that the FCC lacks this authority, and others have said it's covered by some of the ancillary authority. I would like for any panelists, we've had some discussion on some of the key cases that you've already pointed. Does anyone else want to be heard on this authority question? And also, is it affected in any way by any of the pending bills in Congress on this issue?
So I'm going to build on the remarks of Commissioner McDowell. And so the way the jurisdictional question works is that the FCC has either direct statutory authority or it has ancillary authority. And this is essentially an authority, a provision that says the FCC can enforce the provisions in this act through orders and rules. And there are several different provisions in the Communications Act that say that. And the feeling you get from the Supreme Court decisions is that the Congress wanted to delegate to the FCC pretty broad powers to manage communications. This was a complex, fast-moving area. Congress doesn't want to deal with it. I mean, that's sort of the tone you get from the decisions from the Supreme Court down. And people could disagree with that. People could say, oh, it would be better if Congress had to speak every time. It would be better if the FCC didn't have such wide-ranging authority. But it's hard for me to read those cases and read them any differently. And even the opponents of those cases of ancillary jurisdiction, and the most notable opponent is Jim Speda at Northwestern, a law professor I've debated often on this point, and he has to make the argument that those cases can't mean what they say. They have to be narrower than that. You know, kind of like in con law, if you had Larry Tribe, a lot of the cases couldn't mean what they actually said. They had to be narrower. And so the cases are actually fairly broad, with the idea that Congress doesn't want to regulate, Congress wants to leave to the FCC, and the decision will, I mean, the Comcast appeal will help determine that case, but I think it's really hard to read those cases other than providing a lot of jurisdiction authority.
Can I speak to the pending?
The pending legislation?
Yeah. I mean, I think I made, my thoughts clear on the statutory authority in my original remarks, but pending legislation pretty much is, I mean, it's not important at all. I mean, imagine if somebody introduced a bill, and there is a bill in Congress that would give that would be more explicit about the FCC's authority. And if that actually had an effect on this Comcast case, you can imagine you'd have the absurd result of that any single member of Congress who wanted, to take away the FCC's authority on a particular matter could just introduce a bill. So the courts have recognized that, pending legislation or even legislation that, was considered and didn't pass really doesn't say anything to the legality of any particular measure or statutory authority any particular measure. And I think it's pretty well settled.
So you don't think this is going to pass?
I don't think this, look, Congress is dealing with health care, they're dealing with climate change. This is not high on their list. So there's a lot of other things. They're dealing with an economy that's in the toilet. So there's a lot of other things on their mind than passing net neutrality. And there's this NPRM out there. That's what's really important, right? You've got the expert agency that's already moving forward. So I don't think Congress necessarily sees the need to do anything here.
Did you want to respond? Or do you not feel it necessary?
Well,
or did you want to respond?
Okay, I mean, I do agree with Gigi that the most likely congressional scenario is that net neutrality legislation doesn't pass. We do have this interesting situation where I think the oral argument in the Comcast decision is like January 7th, 8th. So you've got the Comcast decision going down one pass, so the court makes a decision late spring, maybe sometime. And the NPRM on net neutrality, which to some extent is predicated on an assumption about authority that's called into question in that case, and I don't know which one goes first, but I do think that in an interesting way, I have to say, as somebody who's really closely followed the Comcast case, and again, I don't know if we want to get into it in more detail at some point, but it calls into question not just the FCC's authority. The facts of the decision called into question how you could manage your network. So there is, in some sense, at least on the part, just from a practical business perspective, a desire to have some certainty, which is one of Gigi's points earlier, which I agree with. So squaring the circle of providing certainty without producing onerous regulation or onerous rulemaking is very tough to do.
I want to let you know that we are open for questions now. I would remind people asking questions to please ask questions so that others can also ask questions. Okay.